Thank you very much for joining us today with members of our board who are here to talk about the current consultation on the proposed changes to the Articles of Association. My name is Leanne Kenny. I'll be hosting today. We have an hour to sort of go through a little bit of background on the consultation and then take your feedback and questions. We do have a housekeeping slide just to remind you that we are recording the session today, and we will make that available in the member hub for members to watch who aren't able to be here actually on the call. Please don't make your own recording. We only have consent for us to record and to publish that in the member hub. And we also have a request for you guys to please turn your cameras on to try and make this a little bit easier for people to communicate with faces rather than initials. So if you feel able to do, we'd love to see you, and please do put your cameras on. So we have an hour. Like I said, I'm going to hand over to Andy just to do a bit of a background on the consultation. So Jenny, if you can move the slide on, and then I'll hand over to Andy.
Great, thank you very much. Welcome everybody. Great to have a chance to talk this all through with you. We have the first slide up. Just going to take a couple of minutes to sort of agree, to set out what the objectives are and what the consultation process and timeline is, and then we'll turn to you guys for feedback on where we are. So objectives. We've got the next slide. So as I think we've said, the main reason we feel we need to modernise the articles is firstly to ensure they're compliant with current legislation we're currently running with them. Not so, we're trying to make it absolutely clear how the company operates today and to address the ambiguities that are in the document and make it a clearer and easier to read document. We think that provides a solid foundation for any future changes. Next slide. So Simon, Kieran and Patsy have been working with me as a working group, trying to make sure we make the consultation as fulsome as we possibly can. Launched it on 7th of June. With a number of opportunities, including this one. It closes on the 9th of August. We'll get all the feedback and publish it, and then we'll make any changes that we think are required as a result of the feedback, and then communicate those to members and put them to members at the AGM. That's the plan. So I think that's enough for this point in the meeting. So should we open up and take people's views, take us off slides so we can all see each other? Would be good.
Thanks, Andy.
Right.
So, feedback, questions, please do raise your hand.
Anybody want to go first? Otherwise, I've got a bunch of stuff that we've had come in so far, which I can take you through at any point, but thought it'd be best to get to the issues that this group's interested in as a first point.
Q, do you want to take yourself off mute?
Yes, hello. Sorry that my camera's not on. I know it's normally on, but I'm having some technical difficulties today.
That's okay.
I have one hopefully small area of concern, which is the new clause 59 on votes of members, which just simply says that the voting rights will be set out in a bylaw. This reads to me as if the board could, of their own accord, change the voting rights of members. And I think there should be a clause in there, as with there was a previous clause on membership fees, which said that changes to membership fees had to be approved by 75% of the membership. So I think the same should be true for changes to voting rights.
I'd have to check that, but I don't think it is at the moment. So I think, the board can unilaterally change.
Okay.
I don't think we've changed anything. I don't think we could ever do it, just so you know. And I think it's, the voting rights is clearly one of those things which, if we can get a stable base, we should move on to and have a look at what we can improved. So, in line with the idea of not changing anything, I think the rule is that we have to consult with members, but then we can decide and change. So I wouldn't likely make that change, because I think if we do that, we break the idea of trying to just make a clear baseline of how we operate today.
Well, yeah, if that is the case of how it operates currently, then fair enough, keep it as it is. That's maybe a discussion for another time about whether that change should be introduced.
Thanks, Stu. I'm sorry, I didn't see which order the hands go up. Can anybody else say that, or?
Get Jim next.
Jim.
Oh, Jim, do you still have your hand up?
Jim's disappeared altogether. We better move on to the next person.
Hang on.
Oh, no, Jim's still there.
I can see he's trying to get himself off mute, I think.
We'll move on to
I saw that I didn't see other hands up. I'll let those go first if that's
No,
okay.
you first, Jim. It's fine.
Okay. The tone that I'm getting is sort of, we need, and literally have been said, we need to put the past behind us and move forward. The analogy I'd draw is perhaps then the government should just sort of ignore the COVID inquiry and Boris Johnson's missing phone and everything else, or why water companies are dropping crap in water, and just pretend that didn't happen and just move forward. I don't think, with respect to the board, that's actually helpful. It's a bit like sort of literally papering over the cracks, and what happens when you paper over the cracks is the building falls down eventually. The problem I'd suggest you've got, and without going into any detail of the existing or the proposed specific changes, is that the proposal is for the constitutional change to be voted on using the weighted voting system that's currently under the spotlight and in question. And if you use the weighted voting you're basically, if that is found to be unlawful, you're then using an unlawful voting system to change the current articles, in effect, to try and reverse history and try and pretend going forward it looks lawful, but it's used an unlawful mechanism to get there, and that would be void, and not voidable but void. So we still haven't had, and we've raised, a number of members have raised significant concerns and gone to the expense of getting more than one opinion from a silk, an opinion that was given a wide brief, and indeed you can see from the opinion that the silk rejected one of the primary questions that was raised in respect to the lawfulness or potential lawfulness of weighted voting. It wasn't an opinion that was steered by the way that he was briefed. He was given carte blanche effectively, and we've agreed to share that brief with you in a quid pro quo with your brief, which you've refused to do. It's not us saying we know the answer. It's us, which is, I think, how you tried to characterize it in the last members' call, Andy. It's us saying there's a big question here. And until you address that question, you can't actually move forward with the changes that you are putting in the consultation. So in fact, it's you who's saying we know the answer, although I suspect you don't, not us. There were 4 reasons or difficulties with the current lawfulness that were identified in the opinions and supplementary notes that were provided to you from Ian Mitchell. You accepted in last year's AGM that you had, and apologized for mischaracterizing your own silk's response as being one that dealt with that in its entirety, because in fact it only deals with one of the 4 points. And that response has been responded to, if you like, by Mr. Mitchell in a supplementary note again, which has been provided to you. How can, in good faith and acting properly, the directors try and plough forward with governance changes without first dealing with this fundamental problem? And if they are, can I ask each of the directors on this call whether they think that, for example, inquiries into past government behaviour like that of Boris Johnson should just be ignored and we should move on and pretend it never happened? Because that is essentially what you are doing yourselves.
Well, I personally reject the idea that we're doing that at all. We're just continuing to run the company the way it's been run, and tidying up the article so that we can move on. If you want, as I've said, if anybody wants to take a legal challenge, that's up to them to take it. From my point of view, we are confident that what we're doing is legal and straightforward, and I don't see any reason to do anything else. I did inquire about this question about you raised last time out about taking this to the High Court. By the way, it cost us over £500,000, not an expenditure I personally would recommend the company spending. It seems to me, that there are 2 or 3 members who believe this is a significant issue. Nobody else seems to. They can vote against this if they want to. Straightforward, simple. So that's my position. It's nothing to do with. I don't think it has anything to do with COVID inquiries personally.
Simon, do you want to come in?
Yeah. Hi, Jim. I think the analogy with Boris Johnson and the water companies misses the mark for a couple major reasons. The first is that the water companies haven't basically gone through an EGM or other similar event that's replaced the entire board with a view to actually trying to fix the problems of the past. In fact, just yesterday, Ross said that no regret. The old Ofwat CEO, who then went to work for Thames Water, has refused to apologise for either her role at Ofwat and its failure as a regulator, nor for what they've done at Thames Water, handing out billions in dividends that they weren't legally allowed to pay. Your suggestion is that the company is acting unlawfully, but it's currently unproven. And my question to you would be, let's say hypothetically the company has been acting unlawfully, then what? What is the outcome that you are after? What is it? What is it that you want to achieve?
Hi, Simon.
Hey.
Well, I think we're probably on the same page about the water companies and possibly even about Boris Johnson's missing WhatsApps. But you and I had a number of conversations during the preparation for the EGM, and then when you were considering whether to stand for the board or not. And I don't want to breach any confidences, but I had a clear impression that you intended at an early stage to investigate the lawfulness of weighted voting if you were elected. So the outcome is literally to get the company conducting its business within the law, which should be the objective of each and every director. And having had a number of dealings with you, I'm sure that is something that you would consider a very high priority. The problem with the approach that you're currently taking is, as you say, if hypothetically, I wouldn't say it's hypothetical, but if arguably the weighted voting is unlawful, then any changes or indeed votes that are taken using the weighted voting, if it is an unlawful process, are simply void. And so it's sort of like building a building without having proper foundations.
It's a house of cards, Jim. I understand that, but my point really stands then. If what you're looking for is to make sure that we get to a rock solid legal position, notwithstanding where we are now, then it seems to me that the work the board is doing tackles that. The question I would ask you,
respectfully, you're using what, if it proves to be the case, the failed mechanism in order to get to an outcome that may or may not be.
But the failed mechanism is the current process by which things are being done.
Yes, so the proper way of doing that would be, we haven't, had a response from the company on 3 of the 4 reasons why the current articles are unlawful.
Right.
Andy, it was claimed to members prior to last year's election that that response had been given to us, although it wasn't published by the company to the members.
Mm-hmm.
I immediately pointed out that only 1 of the 4 points had been covered.
Yes.
And respectfully, I would say relying on the St. Paul's case is wafer thin at best, because it wasn't a point in dispute in that case, the 285A point. It was both parties agreed it, so there's no actual court. Whilst it's in the judgment, there was no argument and decision by the court because it suited both parties on the facts of that case. A case that's so obscure that I had to go to the barrister who was in it in order to get a copy of it. It's not published anywhere. You might guess that I'm not in this for laughs and giggles.
I guess that is a good question. What are you in it for?
What I'm in it for is for the company to operate lawfully.
And what I'm saying is that it seems to me that by November, if this passed, without having to go to any additional expense, we could be absolutely rock solid that we are.
No, because you're using the weighted voting system to get there, and if the weighted voting system is unlawful, whatever is done in November will be void.
But so would have everything that's been done since it became unlawful, correct?
In 2009, correct.
So do you want to
I'm
roll
not
back?
chairman, as I've said before. So
do you want to roll back the clock to 2009 and reverse every decision?
It's a question of whether what I want to do. It's a question of law.
But the law also balances practical reality with what's good for the company and good for, like, clearly the company is trading in a way at the moment. It doesn't retrospectively
create something. It doesn't retrospectively. If it decides that the process is unlawful.
Okay.
And as was explained in Ian Mitchell's opinion, this isn't a criticism of the original drafters of the articles in the 90s, because it only became unlawful in 2009 when Section 285A was enacted. Also, one of the other issues is that the articles link subscription fees to voting rights. That was and again, when the company originally started business, subscription fees and voting rights were linked. You paid more if you had more votes.
We don't think that's true.
It is true, because we've just provided you with a document from Nominet's own website that's archived that shows that that was the case.
But it was never enacted, so it was never true, as far as we can tell.
Well, it was on the website, Andy.
Yeah, but that was very early on in the days before. If you look at the documentation, it suggests that it's been a flat fee from the beginning. In actual fact, in actually what people paid. So things like that, I'm not quite sure again what it's going to do for the company going forward.
Well, what it does for the company going forward is that if putting it in simplest terms, if weighted voting is unlawful, then the voting in the company reverts to the that is stipulated in the Companies Act, which would be 1 member, 1 vote.
And could it have interesting and unintended catastrophic consequences, couldn't it? I mean, 1 member, 1 vote is a very democratic way of doing things, but my personal opinion is that if we move to 1 member, 1 vote, we would actually endanger the company, because it would be possible for a small amount of memberships to capture voting rights. So I think here we need to be kind of careful.
Actually, with respect, it's the opposite that's true. The company is arguably already captured by the large members who have the dominant voting rights.
At least they have a commercial involvement corresponding to their voting weight, and it's quite difficult to fake money. Whereas it's not, if you have a large number of domains under management, it's because you maintain those for yourself or on behalf of clients. It's one of those things that's difficult to fudge without spending a lot of money. If you consider the number of people who get involved in a vote being about maybe 100, 150, and the cost of a membership is £500, I only now need 160 times 500 to be able to capture the company, a much more likely outcome.
Sorry, there are 2,500 members already.
Anyway,
can I
Matthew,
step
I
in?
think wanted to input on this piece, didn't he? Matthew?
So, Matthew, I saw that you sort of waved your hand, and you've been waiting very patiently. And I know, Dan, you had your hand raised first, and Kieran have also.
Yes, I thank you for spotting. Thank you for spotting my polite gesticulation, but it's sort of very related to the polite debate we've just been having there. My understanding of it is that before the UK company law, and I'm not a UK company law expert because I'm in Jersey and we don't enjoy UK company law happily, that the articles and the weighted voting was all fine and dandy until the UK company law was changed in whatever year Jim said. And subsequent to that, there is an unresolved question as to whether the weighted voting may or may not be appropriate or correct or lawful. My question is, leaving that aside for the moment, if the new articles are passed as drafted, and leaving aside the method of passing them, would those new articles then be totally lawful and unchallengeable, save again for the method of their passing, if they then got through? And I think maybe that's a question for.
I think we disagree probably on that. I mean, we think so, yes.
Yeah, you think so.
Of course, we can't say they're unchallengeable. You can challenge them.
No, you never can.
Right,
Now,
so,
a very
we think so. You know, I think that's clearly what we're trying to do is remove the ambiguity.
Excellent.
We can move on to, you know, further debates on topics that are of interest to members, so that we've got a firm base to operate on. So, you know, we think this is the right way forward, and that's what a vote from the members is about.
And tidying it all up is absolutely a good way of doing it. Now, having got that far, then, if we pass by hypothetically as a sort of thought game, how we get there, if the articles as drafted are passed, is Jim then happy that they are unassailable in terms of the weighted voting is then entirely legitimate?
Are you putting that question to Jim, Matthew?
I'm afraid I am. I'm not sure that's allowed, but it would. I am putting it to Jim to see, because I'm expecting him to say, yes, that's no problem. In which case we're then only having a little bit of argy-bargy about the method. We're all agreed with the destination, and it's just the method of getting there that is subject to such
okay, if Jim can answer that question with a yes or no, because there are two other people who've had their hand up for a really long time, then I will allow him to answer.
Quick.
It's a yes or no, Jim.
You're asking a lawyer to answer yes or no.
I am.
Yes, please.
If the method reaching the new revised articles was lawful, then they would be lawful. If the method, so not getting a yes or no answer, I'm afraid, Matthew. If the method used to getting there is unlawful, then they remain unlawful because of the method.
Yeah, absolutely.
Okay.
So my answer is the best thing to do is to deal with the method first, so that uncertainty is removed. And that's really all I'm saying.
Thank you. That has answered my question. Once they are passed, then the ambiguity is gone. That was a yes.
Not quite, because if they're passed using an invalid method, then it isn't passed, and that's why I think it should be dealt with now before we go to the trouble and expense of trying to get them passed.
Okay, right. Let's move on. Dan, you have very patiently waited with your hand up. What is your question?
So I mean, it's been touched on already somewhat, but it's around the tiered subscription fees.
Yep.
So it certainly appears from the archive that Nominet was offering tiered subscription fees. Now, I found it interesting that Andy seemed to indicate that some kind of research had been done on that to disprove that point. But frankly, I've been very disappointed that we've not actually seen any response from Nominet on this. I think it's quite a serious thing if members are pointing out that Nominet appears to be misleading members, providing documentation of Nominet's own website archive, and Nominet doesn't then address those concerns and at the very least explain, we've looked into it, this is what we found, this is why we don't think that's the case. We've just had silence. And I mean, frankly, as someone who wants to see Nominet rebuild the trust with the membership, this is very frustrating to see, because it just feels like Nominet is missing these opportunities to step up to the plate, to be open, to be transparent, and to work with members to address these types of concerns that are arised in a reasonable and productive way. And instead, some of these things like this seem to just be ignored, resulting in these issues bubbling up. And
sorry, we're in the middle of a consultation process, so we're not going to ignore it. We've said we'll publish answers to everything. So, you know, and I'm giving you the answer today. So what's the issue? I don't understand.
Well, this has been something that's been discussed on the forum for the last for a few weeks now, at least. It's been raised multiple times.
We're implementing a process which is open to all members to put in responses, which we're going to respond to. I haven't told the team to go off and engage in the forum to and fro. I mean, so today I'll just read to you what our response is likely to be. It's, you know, the articles and the website from 1996 set out the possibility of a tiered charging structure, but in practice it was never implemented. The reference to this was removed from the website in June 1997, so it was only there for a very short period of time. And the consultation is clear and has been clear from the beginning that one of the reasons we're doing it is that there really is a gap between what's set out in the articles and what we're actually doing. And we need to tidy that up. So, you know, please, we're not trying to hide anything here. It's just, you know, the process we've set out is very clear, is to involve all our members, give everybody a chance to respond, and then come back and explain things. So I'm sorry you're feeling like that. Definitely happy to give you the answer now, and we'll publish that answer along with all the other answers we publish on all the things that people put in.
I mean, I would suggest that it makes sense, but considering the question is more of whether or not the explanations given on the consultation itself were misrepresentations, it's probably would have been worthwhile Nominet coming back and addressing those instead of waiting.
I can talk to that. It says the consultation states that Nominet has always had a flat membership fee for all members. And what it should have said is Nominet has probably always had a flat membership fee for all members. There you go. I fixed it.
We've got no records of it ever having implemented on anything other than a flat membership fee.
I mean, if you want,
we can literally show that if we paid it, it would be great, but we can't find anything.
Yeah.
If it is, it's definitely only between the period between sometime in 1996 when it was on the website and June 1997 when it was open.
Where the volume of people and the number of domains under management was so small that probably everybody fell into the first camp anyway, and therefore the outcome was the same. But if you want us to update the language to just remove that ambiguity, I think that could be done. But I mean, we are looking at adding a word.
As I say, I think I think it's just about accuracy and making sure that we're being clear on what things are. And obviously, if Nominet doesn't have any internal evidence to show that that was the case and that it was just a thing on the website that never actually happened, then that's absolutely fine by me. It's just when there's questions like that about potential misrepresentations, I think it's really important that those get properly addressed as soon as possible.
Yeah, I think effectively Nominet has always had a flat membership fee. The bracket there of less than 50 domains puts you in the 500. Means that everybody for the 6 months that was live on the website until June. I've shared the link to the archive machine. If that could be redistributed to everybody, you can see the Wayback Machine and it's time stamped, and you can see when it moved to the text we're now familiar with. So it looks like it was probably there for a small period where they, you know, toyed around with the idea of doing a variable tiered approach. It got to the point where they scrapped it before anyone had actually climbed out of it, before anyone had hit the second tier. So I understand what you're saying. I think in the pantheon of things that we need to be worrying about, it's probably errs on the side of, you know, typo or mistake as opposed to attempt to mislead and a mischaracterization. But there you have it. Thank you for sharing the link.
Kieran, Jim, I acknowledge that your hand's up, but I just want to go to Kieran first. Is there anything that you want to add on this specific topic, Kieran, or do you have a question on a different topic?
No, I just wanted to just want
Oh,
to say,
sorry. Sorry.
Kieran,
I actually said
not
Kieran, not Kieran.
oh, Kieran. Okay, I'll mute again.
Shush, Kieran.
Terrible
Kieran,
accent, Leanne.
Kieran, are you there? Or have you gone? Right, Kieran is gone. So I'm going to
I'm
come back
here,
to
I'm here.
Kieran. Oh, you are here. Excellent. Gosh,
Sorry, I
this is
was
going
on mute.
terribly well.
Yeah, I would like to actually correct what Andy Green said in response to Q right at the start of the call.
Oh, right. Okay.
Article 52.1 of the company's articles clearly says a bylaw to determine the subscriptions payable by members after 31st of August 1997 and the voting rights to which they are entitled. Therefore, where is this bylaw for the subscription fee? Does one exist? And then a second follow-on question from that is, there's no provision in the articles or even what you're proposing for a joining fee. So the joining fee is completely unlawful. There's a provision for a subscription, and when someone joins the company, there is a joining fee and an extra subscription fee as part of the application, but there's no provision for a joining fee. So when will you reimburse these that you should have collected?
As I say, we haven't had, I think, a bylaw in place. We've had a common practice. People have paid it under contractual law. I'm fairly confident that's fine. In having been in similar situations in other places in the past where these things happen, and we're just carrying on with current practice. I don't think I misled you. We're tidying all these things up because you're right there. It's all nonsense if you try and get into the detail of it.
But to follow
right.
that on, then there's no bylaw for the voting rights either, then, which would be required to be sealed under Article 45 by the company seal.
I don't think there are either. I can't recall. Can anybody remember whether we have a bylaw? I don't think we have either bylaw.
We do. We've got a voting rights bylaw.
We have got a voting rights bylaw.
Yeah.
Fine. So
And the new articles propose a subscriptions bylaw.
correct. And they were there before, but we're going to have one this time. And we're saying what it is. So there's never been a subscription bylaw, but there has been a voting bylaw. The voting has been changed. That's right. Sorry, I'm not remembering correctly. And that will have been done properly, I'm sure, by the team.
Okay. Jim, you have your hand up?
Yes. I think it's slightly disingenuous to brush over what was happening in 96 and 97 by saying it was on the website for a while and then it disappeared in 97. 97 was actually quite important, as Kieran, not Kieran, I'm getting my pronunciations right, said in respect of the expiry of the right to claim to raise subscriptions happens or it runs until 97. So the fact that there was a subscription payment linked to voting rights up until that point is not a coincidence, because at that point the articles anticipate a number of changes and bylaws to come into force. And as Kieran just pointed out, in fact, it appears that no bylaw came into force with relation to subscriptions as was required by the articles. They're not ambiguous. They simply haven't been complied with by the company since 97, 98, when that right under the original articles expired. Well, it's an interesting suggestion that because people have been paying it, thinking that they had to pay it, they therefore the payments were lawful, rather than the fact that they're
not.
not.
A lot of case law on that, so that's straightforward. I think that piece I'm not worried about. I mean, I agree with you, Jim, completely. That's why we're involved in this exercise. It's nonsense to be sitting here with a set of articles which are not being implemented. That's why we're going forward with the process. That's why we're hoping for members to support us in getting the company under a sensible agreement. But there's been lots and lots of situations where people have received services and paid for them, and then claim they then don't have a contractual agreement, and there's a huge amount of case law on that as well.
And situations where some people are receiving those services and not paying for them at the same time.
Sorry.
So there is a dichotomy there in the way that the company dealt with its some of its members historically.
I don't understand the point.
Well, as an example, directors don't have to pay a membership fee, yet they get the benefit of the services that you're referring to. So it's certainly it's demonstrably happened that you can provide those services and not charge a not charge a subscription fee.
For sure. Again, if that's something that a member wants to take up in law, I'm very relaxed about that. There's an obvious reason why board members.
But coming back to taking things up in law, you mentioned earlier that you had spoken to somebody about the cost of seeking a declaration in court, which presumably would be under the Part 8 procedure, which is the low cost, because the facts are not in dispute here. It's a question of the law. It's a fairly narrow question of law. You quoted a figure of £500,000 that you'd been quoted. Given that we have non-execs and yourself standing explicitly on a ticket of transparency, and here I'm looking at Kieran, not Curon, and also Simon, could you please give us a copy of that cost estimate? Publish
I
it.
haven't even seen it yet. I'm just telling you, I inquired about it. Right, so they have no information. They first time they heard about it was when I mentioned it now. Nobody's seen it. I inquired. I was interested in what you said. We've got to go to the High Court, right? So I think we need to be realistic about this idea that you have a low cost discussion with the High Court of the UK is.
But you can have relatively low cost. I mean, I don't want to be trite, but there's High Court and there's High Court. I mean, it is all the same High Court, but there are cases. The cost in litigation, without teaching a grandma to suck eggs, is normally in the gathering together and provision of evidence, and the time spent by lawyers doing that. In a case like this, there's minimal and probably no evidence in dispute, as a matter of fact. So
I'll come back personally. I'm going
but
to
if
come
you
back to this question if and when, if the members don't decide to.
But you're relying on a statement that you've just made in this call, Andy, that's going to have, it was presumably intended to have a chilling effect on members.
No,
you're now telling me that you haven't actually seen a written cost estimate.
Directing in response to you. I'm confident and happy with the process we've got in mind. I was interested mainly because if members decide not to agree to this, we'll still have to decide what to do. And I was interested to see what the cost would be.
But it's more appropriate, surely, during the consultation, whilst there is members need to take an informed view. If you are saying that it's going to cost £500,000 to go to the High Court,
saying that was
it shouldn't be that difficult to provide.
So
can I ask you to undertake here to obtain that as a written cost estimate and publish it to the membership?
Well, you can, Jim, but I'm going to say no.
I expected you to say no. I expected you to say no because it's extraordinarily high.
You can vote against the process when you can't actually, because you're not a member, but you can ask your member colleagues to vote against the process. You can do all those things, Jim. That's the process, right?
Okay, let's move on. Dan, you've had your hand up for a while.
I'm going to change the pace a little bit. So one concern that I saw when reading section 13 was about decisions by email of the board.
Yep.
So I'm very conscious that we already get a fairly limited view of board decisions through the notes instead of full minutes. So I'm a little bit concerned that this could potentially result in various decisions being made basically behind closed doors on email with no kind of visibility to the members, even through notes. So really throwing that back to the board members.
So you do this. Is absolutely normal practice. Is boards occasionally have to do things urgently. They may be administrative, they may be to do with contracts, they may be all sorts of things. I recently had to do one at Water Aid over some changes in Ugandan law, and we needed to get an authorization for somebody to become a director or something. Those sorts of things happen all the time, and then you minute them at the next meeting.
Okay, so they will be.
Every email correspondence gets minuted at the next meeting, and therefore is included. So nothing. And the reason you generally make those unanimous, which what I think we've agreed there, is just to ensure that there's nothing strange that can go on underneath the covers.
Okay, just so long as those are being recorded, then that addresses my concern. Another one that I wanted to pick up on as well was section 5. So that's relating to board members' memberships. Now, I appreciate that the idea is that this is to maintain the status quo, but it seems to me like this is a section where there's a lot of opportunity to very much simplify things. For example, why not simply have it that the articles say that board members must hold a membership in their own name, and it's then down to board members to ensure they're fulfilling that requirement of getting a membership, instead of having all of this complicated process of they get it and then it gets cancelled when they leave, and which has potential gaps if members have their own membership before they join the board. And all of these things, it just seems like something that can be very much simplified and is probably worthwhile putting some thought into now, instead of waiting for a second round to go over exactly the same thing.
But certainly I think we should try and make the wording clear that members who hold their membership retain their membership. If they have it before they become a board member, they don't lose it. That's not what happens today, and it's really for the elected and for the appointed directors of this occurs.
I'm conscious that I cut Kieran off earlier, and he actually had started speaking. So I just want to go to Kieran again, just to give him the opportunity to actually say what he wanted to say. I know we've probably moved past the point, but Kieran, do you want to take that opportunity?
Sure, why not? What I wanted to say broadly was, I mean, I agreed with Simon, what Simon was saying with respect to Jim's concerns. I've been listening to his concerns about what the legalities are and so forth. But then, so I have to make a decision on what I think is best for Nominet, and that means Nominet and how then the members and how it all works. And it just strikes me that going back in time and questioning something that happened a long time ago, and thereby throwing up everything that's happened since then into question, because of some kind of concept of legal purity, is not a great idea for the organization, in the sense that I don't think it'll really achieve anything, and it would throw up a bunch of questions. Whereas what we've got here, at least this is how I've been persuaded through this consultation, is we've got a way of tidying it up here and moving forward, and then we can move forward and, if necessary, make change down the line. That's what is sort of the promise of this, is that we do a partial clear up. And as most people on this call know, the Nominet's had a very messy history. And what this is a partial clear up of that, partial tidy of some of the weird aspects that have popped into the articles over time, with the promise of a future clear up later in a sort of big open consultation. So that's what I'm signed up for. I'm up for sort of resolving some of these issues, rather than going back into 20 years and saying there was a mistake made 20 years ago, a mistake made 15 years ago, let's try and fix it now. I think the best solution is to say, right, how do we move forward with this, keep everything as it has been for the last 20 years, and then create a system where we can make changes going forward. So that's where I'm coming from. And I think this is probably the best way to do it, rather than to look backwards. But that's what I wanted to get across. On the board membership thing, I was actually asked this week whether I wanted Nominet to pick up my membership while on the board, or if I want to pay it myself. And I said, although I really was in two minds, I said, well, the board, Nominet would pick it up while I'm on the board, and then I'll pay it while I'm off the board, simply because there's every other board member's That's the way it works. If people feel that that's a big issue, I'm happy to change my mind. It's not really, doesn't really bother me either way. Just on that component.
Thanks, Kieran. Right, I can see that Jim and Kieran have got their hands raised, but I know, oh, Andrew, aha, as if by magic, I was just going to come to you because I know that you had some questions, but you hadn't had your hand raised. So, Andrew, do you want to ask your questions and then we'll move on to Jim and Kieran?
Yeah, I actually want to ask a slightly different question following today's call. So it was mentioned earlier that there was only 2 or 3 people interested in this argument of the weighted vote being unlawful, when the reality is that we wouldn't be having this article change or at the AGM if it hadn't been for those people that were willing to put the hand in the pocket and change and get a QC's opinion, and people like Kieran, Michael Toth, Angus Hanton, who put the name to it. And I think there's only 10 people on this call, so if 5 out of 10 are interested in it, that's all that's interested in the membership. And then I find it a bit disingenuous to sort of criticise that and say to Jim he's not a member. I worked for Dulwich Storage as well, that funded the opinion, though I wasn't directly involved with that. Jim did that with Angus. I earned the money selling the main house to pay for it, and there's been a lot of effort by the members to look at this and get this far. And Nominet's solution goes some way, as Matthew said earlier, goes some way to fixing that and making it lawful. But to sort of shout down the people that went to the effort in the first place is just not really, makes me feel very, very uncomfortable. And we're seeing it on the forum now with I'm getting attacked. I think a moderator went in last night and deleted about 3 posts that were verbally attacked at me from one of the non-executives. Now, I think everybody needs to calm down a bit and sort of get it over the line. And as for costs in the High Court, there is a mechanism to solve it, and it was used recently by the CBI in their AGM, so it's not unusual to revert to 1 member 1 vote. And they had a problem with weighted voting because the larger members had resigned, and they reverted to 1 member 1 vote at their AGM. So it's not unusual to sort it out in that way. But if you're going to just plough on and use the 10% cap and then rely on, I don't know, 7, 8 large members, that's just as bad as a few members complaining, and we just go around in a circle again.
Simon, do you want to comment on that? I can see that you've got
Sure,
your hand
thank you.
up. It's
Yeah,
limits and response.
Thank you. Yeah, I mean, Andrew, clearly, sorry that you're upset and feel that you've been attacked personally, and I think that needs to change. You know me, I'm a big picture kind of guy. Hence the EGM. I looked at the situation at Nominet from a sort of distant view, and I said, well, look, the way this is going doesn't end well, and put my hand into my pocket, spent a fair amount of money and coordinated a relatively large number of disappointed and disenfranchised members to try and fix the future. And I guess the only point I would make is all of us are on the inside here. We're not being regulated or having any external force come along and tell us, hey, we're concerned about your the legality of how you're operating. This is being self-generated at the same time that we're doing a bunch of work to try and fix said problem. So I look at this like laying out all of the deck chairs and then laying them out again. It's like the thing's in progress. We definitely need to increase communication, transparency. We need to show that we're listening to people, which I do feel that we've made a lot of progress on. But why are we duplicating our work when we have the same outcome? I mean, if you look at our positions, like ostensibly that we're saying the same thing, like where we want to get to is that we want to get to a Nominet that's robust, it's future-proofed, it's secure, and it's stable. And I just worry that some of this work and effort and expenditure is highly inefficient to try and fix a thing a second time. Like, does that make sense? Like, why do we need to duplicate the work if ultimately only the people on this call are going to cause a problem about challenging the legality of it, and we all agree that our interest is in getting to a place where Nominet's safe? Then why don't we just get there? Unless, of course, the interest is actually in getting some money back. And then we have a conflict, because actually what people are saying is, my position is that I want to make sure that Nominet's legal, but my interest is that I'd like a kickback. Now we have a problem. Now there's a difference between what's good for the company and what's good for some members or all members. That's my problem with it. Like, can we not just agree to get to the point where, respectfully, everybody's involved that wants to be, and we have a future-proof Nominet? That's always been my passion, and I think the passion and interest of many members, particularly the people on this call who have turned up to, give their time. It just seems to me, as a big picture guy, a bit ineffective, a bit inefficient. But
well, the two different things there. The EGM was about putting Nominet back on the right path. This AGM is about putting Nominet back up in compliance with the law, and only after that point can you start to look at the things that were raised in the EGM and implement those in the articles. Now, to suggest that people like Angus Hanson are in it for the money is just ridiculous. If you know Angus.
I didn't.
Yeah, well, it's. I think Jim's found a sort of anomaly in the articles and sort of, has found it unlawful, and as a solicitor, that's something he's interested in. Now, if you're just going to say that he's in it for the money,
that's not what I said. What I said is,
can I say something here, please?
yes.
Yes,
Simon had no. I don't want to breach solicitor. You weren't. I wasn't your solicitor, but I don't want to breach confidence with you in any event. But during the preparation for the EGM, you and I discussed at length the question of weighted voting and one member, one vote. I don't recall you having any philosophical difficulty at all with challenging whether weighted voting was lawful or not. In fact, you asked me, and I did prepare for you a fairly lengthy opinion on whether or not it was lawful, and you considered whether or not to bring an action yourself.
I don't need to tell you, Jim, there were a number of issues with Nominet at the time, and when
you decided to proceed very bravely, I thought, and I said so to you at the time, with an EGM using the weighted voting in place.
Yes.
And
because I felt then, as I do now, that it's an unnecessary distraction and sideshow. I mean, ultimately, the EGM was trying to fix the future and the character and the culture within Nominet, upon which everything else stands, right? I didn't think.
But you did say that you would review it if the EGM succeeded, and you brought several people along with you who worked. Didn't put as money in as you did, but put in time and effort in order to get the EGM over the line.
Yeah.
So I'll leave that final question, if you like, unasked and hanging.
Which is why did I change my mind, or am I at liberty to change my mind once I sort of see what the priorities are as I see them, or that I might be pleased with the fact that we are doing an articles consultation which aims to set us up for the future, and therefore think that it's duplicate work?
But it isn't, because if you do it with something that ultimately proves to be broken, it's actually a complete waste of time and worse than doing nothing. Because if weighted voting is unlawful, everything that's now being done and that's now being proposed and then gets done will be void. So why?
It's possible that's true. Of course, when you do the analysis, which I've done going back, I think we found, as I've said on the previous call, we found one vote which changes depending on what voting.
Well, one vote last year would have been the board election.
That was one vote that would have changed. Not last year. Anyway, whenever it was, not last year.
Last year, the analysis was that a few large members' second preference votes are what decided the board appointment.
It's got nothing to do with board appointment.
The weighted voting does. You get 3%.
Yeah, but weighted voting and the board appointments has nothing to do with this.
Sorry.
I think this misses I think this misses the bigger point, Jim. That I think what you're trying to say is that you believe that if we had one member, one vote, then you may be a board member.
But that's not actually that is what I believe to be the case, and analysis suggests that it is. Going back to the point that you're making about people doing this for the money,
that would represent a conflict of interest, wouldn't it?
What?
I mean, your action
not
here,
if it's declared.
But your action here would directly benefit you, and furthermore, wouldn't you create a bit of a moral hazard for yourself if you were on the board that you'd sort of?
Well, I'm not on the board.
Propose to take legal action against, wouldn't you?
I'm not on the board.
I know that, but you wouldn't you?
So I'm not quite following you. I don't retrospectively get put onto the board. If there's a declaration that weighted voting is unlawful, then there would be a requirement to go back and review nearly all of those decisions, as Andy rightly points out, if they had been different. And I think.
Yeah, but I'm sorry to say, but I'm not sure.
Well, indeed.
What we're talking about here affects member elections at all. I would have to go back and check. But
well, weighted voting is used in member elections.
Yes, I know, but it's not as a result of the bylaws.
Weighted voting is only as a result of the bylaws. It doesn't exist otherwise. Otherwise, it's one member, one vote. Well, that's the default position under company law.
But as I say, I don't think, I will have to go back and check, but I'm not sure how the member election thing gets agreed. I think it's completely different from what we're debating here. Whatever we do on here, I don't think affects the member elections.
I don't think that's right, but in any event, I'm happy and have declared an interest potentially in one possible reversal of vote, but that's actually not my motivation. Neither, as Simon suggests, is it financial.
So just so I can be precise, the numbers I was quoting were about AGM vote.
Okay.
What I think these articles are about.
But rather than let's park that, because I'm not sure. Yeah. Not sure it takes us further, but can I come back to what the point that Simon made, where he was sort of suggesting that there was a financial incentive in all of this? Again, I can declare that whilst I was a board member at Nominet, I didn't take any salary because I thought the contract was wrong. At the time, it was changed in 2008 to try and restrict the actions of non-executive directors as well, that the time that I spent helping him with the EGM was unpaid, and I can confirm that I haven't been paid for any of the work that I have been doing in respect of the inspection into the lawfulness or otherwise of weighted voting. Okay. The reason I'm doing this is because I just don't like things that are wrong, and it's not a legal technicality or purity or whatever Kieran said. It's a question of whether the company's breaking the law or not.
Okay, thank you. Kieran, you've had your hand raised for a while.
Yeah, I'm actually going to go back to the hypocrisy Simon just said. And I actually...
Can you put your camera on, please, Kieran?
I haven't got a camera, sorry.
Yeah.
And actually, I'm inviting you to resign from the board as a result of what you just said.
Well,
because
I'm not going to be challenged by someone that can't even put on a camera to talk to me. I'm sorry, communication is 50% plus body language. I don't think it's reasonable to ask someone.
Why isn't this a face-to-face meeting?
Well, come and meet me. I live in Bristol. You're in Cardiff. I'll meet you face to face.
I'm actually going to go back to this hypocrisy.
Talk to me then.
Do I not interrupt me, please? Can you mute yourself, please?
I don't think it's reasonable to be challenged by someone that won't even face me.
I'm sorry, you're interrupting my input.
Wow.
Your hypocrisy here. Why are you involved with this article change when you have a clear conflict here in your weighted voting? It's quite clear that the members of the board that do not have involvement with weighted voting within their own retrospective companies should be leading on this, not members of the board that have weighted voting, because they're conflicted in the consultation and the whole process. So, Andy, I'm asking you, and not Simon, why are they involved, and have they declared their interest, and how is that conflict of interest being resolved?
So we understand clearly the conflict of interest that exist on the board. They are part of the fact that we have a membership with an organisation, and so Ashley and Simon, in any split vote, would not have to. We didn't actually vote on this. We're after all only consulting. It's not very. We're not making a decision here. We are consulting on putting a decision to members. So I don't think any conflict issue occurs. We have a unanimous board decision. If Ashley or Simon hadn't voted, it wouldn't make any difference at all to the situation. So, from my point of view, we are just putting forward to members a consultation followed probably by a vote at the AGM. And we will decide to put forward the vote to the AGM, and we will use our normal conflict procedures, which we go through in detail at every meeting. Rory is fantastic, our company secretary, on that point. Ashley has to leave frequently when we're discussing, for example, bidding for other registry businesses, those sorts of things. We're always on top of this issue, so I'm not at all concerned the board doesn't know how to manage this. It was very well done before I arrived. I've not had to make any changes at all on that subject.
Lovely, thank you, Andy. I am conscious that we are a minute over time, but that we've got Matthew and Dan with their hand up. Matthew, if you could be very quick.
I will be very quick indeed. All I was going to say was, given that there seems to be general agreement that once one is able to get the articles as proposed passed, it solves the weighted voting question. I was just going to suggest that it might be the best bet if Jim and others explained in their responses to the board as part of the consultation what they think the most efficient way would be of doing that, and with the maximum certainty. So if there's a slightly different way of doing it just this one time, then that might be helpful. That's my lot.
Okay,
Thank you.
Thank you, Matthew. Dan, very quickly.
So I think it's basically, I think everyone seems to be agreed that this is a complete mess of the articles. So how is Nominet going to put in place processes to ensure that once the articles are all fixed and updated, this doesn't reoccur again in 10, 15 years?
Okay. Who wants to take that one very quickly? Andy.
Yeah, I think having a firm baseline is really important in that. And I think, we need to move on then. The consultation has two parts to it. Are there any detailed changes we should make to what we're proposing here? We found one or two already. Thank you very much for all those who put in that I think is good. And the second part is, what are the things members would like to change? Now, remembering members need to get, we need collectively to have a good consensus on any change that we need, because these are all super majority issues. So you need a big number of members supporting anything. And so we're trying to gauge whether there are any of these items which are contentious, which are likely to get 75% or in the extreme case 90% vote in favour. And we're really interested to hear that. Clearly voting rights is one of them. And we need to look at what are the other things that people believe we should think about changing in the way we do business today at Nominet.
Thank you.
And I must say, I must apologise if I felt if I really wasn't hoping to insult anybody. It was not my intention. If I did so, I do apologise for that. Just to finish off, these are always difficult debates, but I believe we can take this forward for the best interests of Nominet, and that's what I'm trying to do.
Jim, can you come in on 30 seconds?
Yes. If Nominet is in receipt of any legal proceedings in relation to anything that's in the consultation, will they suspend the consultation?
Andy?
That's two open questions. Don't know and have to consider it at the time.
Lovely. Great.
Well, I understand
Thank
you're
you.
already in receipt of proceedings.
Well, I have not been so informed. I have no information, and I guess neither therefore the Simon and Kieran. So definitely.
Simon is aware of it.
No, I'm not.
Okay, let's leave it there.
No. So I'm not aware of
Okay.
anything. If that happens, we will consider it, of course.
So thank you very much for your time. I apologize that we've gone 5 minutes over, but obviously we had some quite detailed discussions there. So thank you very much to everyone for your time. The consultation closes on the 9th of August, so please make sure that you put your consultation responses in. That would be very much appreciated. And there is a member call scheduled for the 26th of July, if anybody would like to join that too. Okay, thanks very much. See you soon. Bye.